Welcome to week 9 of business law. This week we're going to continue our journey through the world of contracts. Yes, more contracts. There's still more that we have to do. We'll be another couple weeks after this still looking at contracts, and like I've said before, it's just vitally important to everything that we do in the business world. This week we're going to look at some various legal issues surrounding contracts. Specifically, we're going to talk about the writing requirement that exists in some types of contracts. We're going to talk about third parties, besides just the normal two people that enter into a contract. Sometimes third parties also have a vested interest in that, and we'll look at those situations. We're also going to look a little bit about performance and remedies. That's covered in Chapter 18 of the text, and some specific issues dealing with discharge I think we need to kind of focus in on. So we'll be looking at a number of different things this week. The first topic we're going to tackle has to do with whether a contract has to be in writing or not. As we've already mentioned, the default rule is that a contract does not need to be in writing in order to be enforceable. That's kind of counterintuitive to a lot of people, I think, who think that maybe just a handshake type of agreement doesn't really obligate them to anything unless they sign their name on a piece of paper, and that's just not true. In most situations, the default rule is that no writing is required for a contract to be enforceable. So unless there is a law that says otherwise, an oral contract is just as legally binding as a written one. Now, having said that, we know that usually oral contracts are not a good idea. We've looked at problems of proof in one of the discussion questions that we covered. And so it's just better if everything is in writing, certainly as a practical matter, but legally speaking, you can still be bound by an oral contract in most situations. Well, this week we're going to look at exceptions to that default rule and look at cases where a contract does, in fact, have to be in writing. Well, as we said, a contract doesn't have to be in writing unless there is a law that says that it does. Well, we have inherited a lot of our legal system from jolly old England, and in 1677 the British Parliament passed a statute that required certain types of contracts to be in writing in order for them to be legally enforceable. Apparently, back in those days there was a lot of fraud going on, and you can imagine what would happen with oral contracts, especially in a world where there was no such thing as video or audio recording to really prove what was going on. So you'd have situations where somebody entered into an oral contract, but then ended up breaking the agreement, and then it ends up in court, and it's just he said, and there's a huge problem with proof, and it was just bad. And so there were a bunch of scoundrels out there, apparently, in England in the 1600s that were entering into oral contracts, not following through, and then lying about it when they were hauled into court and saying there was no contract. And so the British Parliament saw that was a big problem. They didn't want their people to be defrauded, and so they passed something that is known to history as the Statute of Frauds that required a number of different kinds of contracts to be in writing in order to be enforceable. Well, that was a very influential law that the British Parliament passed, and now every jurisdiction in the English-speaking world pretty much has some kind of version of its own statute of frauds, which requires certain types of contracts to be in writing. Missouri has one of those statutes of frauds as well. We'll read through it really quickly. It says it's section 432-010 says no action shall be brought to charge any executor or administrator upon any special promise to answer for any debt or damages out of his own estate, or to charge any person upon any special promise to answer for the debt, default, or miscarriage of another person, blah, blah, blah. I'll change my mind. I'm not going to read the whole thing. It's really long and detailed. But just know that every state has one of these statutes of frauds. And it's all a little bit different. And so if you're going to be working in a particular state, you or your attorney ought to have some familiarity with this if that's any kind of question at all, or just put it in writing, which is always the safest thing. But anyway, every state has one of these that has different requirements. We're going to look at the major different kinds of contracts that these sorts of statutes cover. So, types of contracts that have to be in writing. Well, the first one, it's a biggie, is any contract calling for the transfer of an interest in real estate. So if you are buying or selling land, that has to be in writing. You can't just have an oral contract to sell land. It won't be enforceable. Not only the transaction of exchanging the land itself, but also anything that has to do with an interest in the land. Remember our property unit, we talked about different things that kind of have a, real estate doesn't have to be land itself, it can be an interest in the land. Well, things like mortgages, easements, leases, those sorts of things ought to be in writing, or they might not be enforceable. So if you're dealing in real estate in any kind, any way, shape, or form, that ought to be in writing. Also, contracts that cannot be performed within a year. For example, let's say that you hire a maid service to clean your house once a week for the next 2 years. Okay, by the very terms of that contract is a 2-year contract. And if the maid service can't clean your house early and get out of the contract in 1 year, the whole point is to have them for 2 years cleaning your house, because that needs done continually. So a contract like that has to be in writing if it goes past a year. Let's look at another example, though. In this example, I hire Glenn to build my new house, and we have an oral contract for him to do that. The contract does not say anything about how long construction is going to take. Glenn ends up taking 13 months to finish building the house. Was that contract subject to the statute of frauds? Well, the answer is no, because in the terms of the contract itself, it doesn't say that it's going to go past a year. We're only concerned about the first type of contract there, where just by its own terms, the contract is going to go beyond a year. In this example, Glenn might have really, gotten his act together and gotten my house built in 3 months, let's say. We didn't know going into the contract, and so something like that doesn't have to be in writing according to the statute of frauds. Again, we want all of our contracts to be in writing if we can do that, but the statute of frauds won't apply to this particular type of contract. It's only when the contract's own language indicates that it's going to take longer than a year to perform is when a writing is required. Another type of contract that has to be in writing is a guarantee contract. That's where a third party comes in and agrees to act as a surety for someone. Basically, the surety is agreeing to answer for that person's debts or other obligations. So let's look at an example here. John owns John's Crab Shack, a seafood restaurant. The Crab Shack enters into a contract to borrow money from the Bank of Newtonia. Okay, that's contract number 1. However, the Crab Shack isn't making a lot of money and the bank gets nervous that its loan won't be repaid. So it threatens to foreclose on the loan unless John himself, not on behalf of his corporation, but he personally signs a second contract agreeing to use his personal assets to pay off the debt of his business. And so the bank's really nervous. They're not thinking that the business is going to make money, Crab Shack Inc. or whatever. So they want John personally to sign on this. Well, the second contract where John is agreeing to pay the debts of someone else, which happens to be his business, if he's going to personally guarantee that, that's a guarantee contract. That has to be in writing. So maybe a more pertinent example to some of us, a guarantee contract's a lot like what happens if you have bad credit, you want to go buy a car, no one will give you a loan, so your mom has to co-sign. Well, if your mom's co-signing the loan, that's basically a guarantee contract, and that's going to have to be in writing. Also, in many states, a contract with a real estate agent to buy or sell land, that has to be in writing as well. Kind of the thinking behind this is that the contract to sell the land, ought to be in writing because the contract to sell the land itself would be in writing as well. We already saw that any transaction involving real estate that contract has to be in writing, and so here you're hiring someone to sell the real estate for you, so the thinking is that should also be in writing. That's called the equal dignities rule, and that just means, like we said, both the contract for the land and the agent's contract ought to be subject to the same formalities. And basically, if one has to be in writing, the other one ought to have to be in writing too. And so in most states, anyway, that's going to have to be in writing as well. Promises that are made in consideration of marriage must be in writing. In the olden days, they did weird things when people got married, but typically now we're just talking about prenuptial agreements for the most part that would have to be in writing. You can't just have an oral prenup. You wouldn't want that anyway because, it really is going to be he said, she said in that situation. Also, contracts for the sale of goods worth more than $500 must be in writing. Now this one's a little bit different because it's not covered by the traditional statute of frauds that we inherited from England. This one's pretty new. It came in with Article 2 of the Uniform Commercial Code, which we're going to look at in some detail later. Article 2 of the UCC covers the sale of goods, and it requires this writing requirement here. The UCC has been adopted by every state. Every state has its own version. They should be almost alike, but some states vary a little bit. In Missouri, it's codified at RSMO section 400-002.201 if you want to go look that up. But it's pretty standard stuff. Doesn't vary much from state to state. So what this means is if you're selling a good, and a good is some tangible item of personal property that can be moved around, that is worth more than $500, a contract for sale must be in writing to be enforceable. So that's important to remember. If you're selling, something that's $1,000, you ought to have that in writing in order to be enforceable. So we've talked about the kind of contracts that have to be in writing. Well, what happens if there is no writing? Well, ordinarily, a contract that's subject to the statute of frauds, which is not in fact in writing, is going to be unenforceable. In other words, if you try to sue someone for breach of that contract, a court is going to say, sorry, I can't help you. I cannot enforce this contract because it was supposed to be in writing and it's not. So for example, let's say that you agreed with Bob that you're going to buy Bob's house, and you have an oral contract, nothing's in writing, and Bob backs out. And so you take Bob to court wanting to buy his land, force him to sell to you. The court is not going to force him to sell to you because there was no writing. And so therefore you don't have a contract that can be enforced, because contracts for the sale of land have to be in writing. And so that's normally what happens when the statute of frauds applies and it's an oral contract. It's just unenforceable. Well, just like everything else in life, there is an exception. And a court might step in and enforce one of these contracts, even though it violates the statute of frauds, if it would be grossly unfair to one of the parties to just not enforce the contract at all. And this is called the part performance doctrine. And so when one of the parties is dutifully trying to carry out the agreement, hold up their end of the deal, has begun to perform and has kind of put themselves on the line a little bit, it would be unfair sometimes to let the other party just walk away from the deal without holding up their end too. And in that kind of situation, a court may step in and force them to perform. Let's look at an example where this might happen. In our example, Laura made an oral contract to buy a house from Renee in 6 monthly payments. This is a contract, of course, that's subject to the statute of frauds because it's for the sale of land. But these two are friends, so they decided they'd just make an oral agreement and shake hands on it. The sale was supposed to close on June the 1st. The entire 6 months prior to closing, Laura was living in the house and making payments to Renee. She also spent time and lots of money remodeling the house. However, on May the 15th, Renee decides to back out of the deal. Laura sues, but Renee's defense is the statute of frauds. Renee says there was never an enforceable contract, so she can back out of the deal with no consequences. Is Renee correct about that? Absolutely. There is no enforceable contract because it was a contract for the sale of land. There was no writing. It's unenforceable because of the statute of frauds normally. But would it be fair after Laura's gone through all this trouble, spent 6 months of her life working on this house, in reliance upon this deal, and paid a lot of money on it and all that kind of stuff? Would it be fair to just let Renee walk away and say, oh, forget it, I don't want to be bound by this contract anymore because it's the statute of frauds? Well, a court might very well think that's just not fair to let that happen. So in a situation where I have an otherwise unenforceable contract and it's been partly performed, then that's an indication that the parties intended to be bound by the contract. In a situation like this where notions of justice and fair play are at work, the court may go ahead and force the parties to finish performing the contract that they started to perform. That's a remedy called specific performance, when you force a party to go ahead and follow through on a contract. And we'll look more about remedies down the road for breach, but that's one of them. And so in a situation that's kind of just be grossly unfair to let one of the parties reap all the benefits here and then just walk away whenever they felt like it. And so a court might step in and do that. Now what's going on here is very similar to our old friend promissory estoppel. And in fact, that doctrine might come into play here too. And you can see why, because Laura kind of put herself out on a limb in justifiable reliance upon this promise. And she relied on that promise to her detriment. So we can see that that would be another theory her lawyer would probably throw in when they go to court here. But certainly the court might go ahead and just enforce the contract as well based upon this poor performance. And so that's an exception when we have the statute of frauds at play. So if the statute of frauds applies, we have to have some kind of writing. Well, what kind of writing is actually required? Well, there's really no magic formula for this, but certainly it must contain the essential terms of the contract. So the big important things ought to be there, like, for example, the number of widgets that you're going to buy, maybe the price of each widget, you know, when they're going to be delivered, those kinds of things. It really depends on the circumstances, but you want your writing to contain all the essential terms of the contract. You don't have to have a nice, neat, formal document drafted by an attorney. And a pre-printed form is okay. Sometimes those are prepared, you know, in a particular business or industry, and that's perfectly fine, but you don't have to go run into your lawyer every time you need a contract. You can just use a form. You can scratch it on the back of a napkin or whatever. It can be very informal. It doesn't really matter, but there has to be some kind of writing to memorialize the major terms of the contract. It also doesn't have to be in a single document. For instance, if you have an exchange of emails between two people who are negotiating, you know, some kind of deal, and they finally, you know, reach agreement on that, it could be just the whole collection of emails could be sufficient to have a writing that really explains what the terms of the deal actually are, and that would be sufficient too. And again, there's really no magic words you have to use. There's no incantation you have to recite to have a writing for a contract here. There's no magic format, but you have to have something that's actually in writing that kind of just touches on the major essential terms of the deal. And so you have to have something that's in writing. And again, there's really no magic formula for that or any particular format. One thing that you do have to have in the writing is that it has to be signed by the party to be charged. In other words, the person you go to court to try to enforce the contract against, in order to enforce it against them, they have to have signed off on it. Well, let's take a look at an example here. Joe and Fran enter into a contract to sell land. If Joe wants to sue Fran for breaching the contract, he won't be able to win unless the contract is signed by Fran. So for instance, if for some reason Joe signed the contract and Fran didn't, then Joe can't enforce the contract against Fran. It has to be signed by her, the party to be charged in this case, the party he's trying to enforce the contract against. And so that's very important. The signature doesn't have to be a full legal name, and here I came up with one that sounds long in Latin, Joseph Ignatius Palmero III. If he signs that as Joe, that's okay, as long as his intent to be bound by that contract is evident. And it's really just some kind of marking on there on the face of the contract that shows that you're agreeing to be bound by the terms of the contract. So in the olden days, you know, a lot of people were illiterate and they would just make a big sloppy X as their mark. That's okay too, if you can prove it's their mark. It doesn't have to be their name or, you know, their full name or anything like that. Again, there's no magic involved here. Also, the valid signature can be made not by the person themselves, but by an authorized agent. We'll look at agency later on at some point, but if you have someone who is your authorized agent, they can sign on your behalf and you can still be bound. So it doesn't even have to be you signing it. If they sign it in the capacity of as your agent, you might still be bound, but it does have to be signed by the party that you're trying to enforce the contract against. We already mentioned this once, but a contract doesn't have to be contained in a single document either. The writing can be in multiple documents, and that's fine. Sometimes the contract will include terms that are located in separate documents, and when that happens, we say that these separate writings are integrated into a single contract. And so we may have one contract, the terms of which are laid out in different places. And if that's the case, that's okay. A contract may incorporate by reference the terms contained in another document. So we may actually do this on purpose, not just by accident. For example, let's say that we have someone who signs a contract to buy lobsters, and the contract says the parties agree to the sale of 5,000 lobsters on the terms agreed to in a letter sent by Joe to Frank on May 17. So the contract here is incorporating the terms of this other document, this letter that was sent by reference. And so what is in that letter becomes part of the contract, and that's okay. So If our, the main contract document doesn't contain all the essential terms, that's okay. It tells us where to go find those terms. And so we will consider all of those writings to be integrated into the single contract, and that's fine. When the contract actually has language in it that makes reference to another document, like we just saw in the last example, that's what we call an express reference. It actually comes out and says, hey, everyone, go look at this other document to find the terms of the contract. And so that's what happens there when it's done on purpose, very deliberately, and the contract language actually says that. Sometimes, though, it's not done that open and obviously. Sometimes it's done by implication. So the contract doesn't come out and say it, but somehow it's implied that this other document contains essential terms of the contract. So let's say that we have that lobster contract, but nowhere on the document does it say how much is going to be paid for the lobsters, which is kind of an important contract term. But Frank stapled to the contract an invoice charging $10 per lobster. And so then we can assume that the terms on the invoice were incorporated into the contract by implication. The contract language itself doesn't say that, but this is all stapled together here, and this is what he's charging. So we can kind of assume that that invoice is part of the contract that sets out the price. And so that's how we might get a term by implication. Well, sometimes people who are writing contracts want to make very, very sure that we don't have any of these other documents contributing terms to the deal, because you might have, two parties sign a contract and everyone thinks that they're on the same page, but then one of the parties comes out later and says, oh, wait, look at this other document. This is really what we meant when we signed that contract. And so somebody who signs a contract may not want to be surprised, 6 months later when the other party claims that there's an email that contains additional contract terms and that wasn't in the original contract. And so sometimes we just may want to prevent that from happening. And when we want to do that, we can include what's called a merger clause or an integration clause within the contract that plainly says, this document that you're reading right now, this is the entire contract, and there are no other documents anywhere else in the world that contain contract terms. And if both parties sign off on that, then that's okay. We won't go look, for those emails or other surprises, looking for other contract terms. So here's an example of an integration clause. It says, this agreement and the exhibits attached hereto contain the entire agreement of the parties with respect to the subject matter of this agreement and supersede all prior negotiations, agreements, and understandings with respect thereto. This agreement may only be amended by a written document duly executed by all parties. And so this is what we call boilerplate language. It's just kind of standard contract language you might even find on a pre-printed contract form or something like that. And a lot of times attorneys will throw this in there just to make sure that we're not going to get surprised later by someone, waving around some email or letter that was sent or something, said, hey, this is what the contract really means. I have additional terms here. The parties had talked about such and such, and this is what they said. Well, we don't want that to happen sometimes, and we'll just want to make completely sure that only the terms that are on the face of this document we're working on, that's going to be all the terms of the contract and nothing else. So we can use an integration clause or a merger clause to make sure that no other sources of terms of the contract will crop up and surprise us later. Well, sometimes it can be hard to figure out what a contract means. And so if you're a judge and these two parties are in your courtroom bickering about a contract, it might be hard to kind of figure out what the terms of the contract actually are. Several reasons for this, but the parties themselves may disagree about what the words on the page mean. They may have thought they were on the same page, but then after they sign it and they're starting to perform the contract, they may completely disagree about what they actually meant. And sometimes it may just boil down to one word or one phrase or something like that and what it actually means. And when we have a situation like that, we call it an ambiguity. If we can't quite figure out on the face of it what a term in a contract is actually talking about. And so if we have an ambiguity, it's cut and dried. If it's, if everyone can understand what the terms of the contract are, it means what it says. But if there's some term that we don't really know what that means, we don't quite understand, what brand of widget it's talking about or something like that, then we have what's called an ambiguity. And when we have that ambiguity, At that point, a judge is going to put into place some principles of contract interpretation to try to sort out what the contract language actually means. And so we're going to look at some of those principles now that the court's going to look at, trying to figure out when we have that ambiguity in there, how's the court going to go about deciding what the contract terms actually are. The first principle that we have is that ordinary words are given their ordinary dictionary definition meaning unless the parties define it otherwise somewhere in the contract. And so, if we're reading along in the contract that says something about a desk, we all kind of have a picture in our head of what a desk is, and so we're just going to assume a desk is a desk unless, there's something else in there that says, oh, well, a desk means it's a very expensive drafting table that has, some arm that will swing out and the table will tilt and it has all these bells and whistles on it, well, okay, that completely changes the meaning entirely. But unless the parties decide to do something like that, we're just going to assume, a cigar is a cigar until proven otherwise. And so we'll just assume that the dictionary ordinary definition is what we're intending, unless the parties redefine a term in the contract some other way. Second, if we have some kind of technical term, we'll give that term its technical meaning unless it's defined otherwise in the contract. So, if you're reading along and you see watt hours or kilobytes or, something, science-y, something like that, we're just, we'll go to the technical manual and, see what that means maybe, but we'll just give it its ordinary technical meaning unless the parties agree, the kilowatt hour means something other than it normally does. So pretty straightforward there. Third, if we have specific terms, that's going to trump a general term. For example, let's say we have a contract for the sale of produce, okay? And the contract uses the term fruit over and over again. Keeps talking about fruit, 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 fruit. Well, then you flip to page 10 of the contract and it specifies that we're talking about Asian pears, which is a very specific kind of fruit. Well, if the seller delivers a truckload of bananas, he can't get away with that. And, he can say, oh, well, this is fruit. Well, you go read the contract and you have a specific term in here, Asian pear, and that's going to trump fruit, which is very general. And so when you have a specific term like that, we're going to assume that's what you mean when you say fruit. So specific terms trump general terms. Well, fourth, if the parties belong to the same trade or profession, we'll give the jargon they use the meaning it normally has within that trade or industry unless it's otherwise indicated. Well, what do I mean by that? Well, let's say, for instance, we have two plumbers. They enter into a contract for the sale of tingle hoppers. Of course, no non-plumber understands what that means, but everyone in the plumbing business knows that a tingle hopper is a special kind of pipe wrench. And that is what the word tingle hopper is going to mean in the contract then, unless the parties define it specifically some other way. So that's called usage of trade. And so if we're trying to figure out what an ambiguous term means, we're reading the contract, what in the world is a tingle hopper? And this is a silly example, of course, but it does crop up, in various different ways. Well, a court can go say, okay, well, these guys are plumbers. What does this word mean to a plumber? Or if we're talking about, dealers in fine gems or, silk fabric or something, we may just go to that industry and say, okay, well, we're talking about silk fabric. Well, they said bolt. Well, what does a bolt mean? How many yards of fabric is that? We can go look at the usage of trade in that industry and try to figure out the meaning from that. And so we can use that to kind of inform us of what the parties meant when they use this particular term. Fifth, if we have handwriting on the contract, that's going to trump typing, and typing trumps pre-printed language. So sometimes we'll have this nice contract form that is pre-printed by some printing company somewhere, and then we actually get to looking at it and it's been scrawled on and things have been scratched out and there's been things inserted and somebody typed in something somewhere and somebody else scratched something else and wrote something in by hand and all that. Well, how do we deal with that? Well, the general rule is here that handwriting is going to be what we look at first, and then we'll look at typewritten terms, and then after that we'll look to the pre-printed language. And so when might this come up? Well, let's say that you go sign up for a new cell phone, so you go to Verizon or AT&T or whatever. Well, you know, when you show up at one of these places, they're not going to sit there and call their attorney on the phone and, you know, draft some brand new contract just for you. You know, what are they going to do? They're going to go to the file drawer, whip out a form, and start filling in blanks. Okay. Well, sometimes we have situations where, you know, the pre-printed form says one thing, but someone, you know, might use a typewriter, and so I know those still exist, at least in some places. Or they may, you know, just take out a pen and cross something out and write something new in. You know, how do we handle that situation? Well, the general rule is, you know, the handwriting trumps everything else. The typing will trump in the pre-printed language of the form. And so, you know, we'll just kind of, you know, the pre-printed language on that form just kind of comes in last in this situation. We'll follow it unless something else has changed it, basically. So that's kind of what we would do in a situation of that kind. So if, for example, the form says the goods will be delivered in 3 weeks, but someone has crossed that out and writes in 2 weeks, and then 2 weeks is what it will be. You know, we'll look at the handwriting first. Now, of course, you may have issues of proof here. You know, who's to say that somebody didn't change it after it was signed, you know, or something like that. I understand that. You know, we might still have an argument once we get into court, but by and large, if everyone can agree that, you know, this is what happened, this is what we'll do, you know, the handwriting is going to trump whatever the pre-printed language says on the form, because we know that parties sometimes like to modify these forms, and so we will go with that unless we have a good reason not to. Our sixth and final principle of contract interpretation when we have an ambiguity of some kind is that we're going to construe that ambiguity against the person who drafted the contract. And the assumption simply is that if you're writing the contract, you know, you kind of deserve the consequences if you screw it up, basically. So if you draft poorly and don't make it clear what you actually meant, then we're going to construe the contract against you, basically. So if there's two interpretations and we're not clear on which one, and you had the opportunity when you drafted the contract to make it clear, then you're going to pay the price for that, basically. So we'll just assume that whatever is not good for you is what you meant, and because you didn't make it you didn't make it clear that you meant something else. Let's take a look at an example of where this might come into play. For example, Kevin is going to sell his farm to Justin. So Kevin draws up a contract that says, I agree to sell you my farm in Jasper County for $100,000. Well, later on, the parties get into the disagreement and end up in court. The problem is that Kevin owns 2 farms in Jasper County, and nothing in the contract says which farm was being sold. So we have an ambiguity. What does farm mean? We don't know. Okay. Well, one farm is 40 acres, but the other is 160 acres. So one is 4 times larger than the other. Well, Justin argues that he thought he was buying the 160-acre farm, but Kevin says he was selling the 40-acre farm. Well, in this situation, an ambiguity could be resolved against the person who drafted the contract, which is Kevin, because Kevin could have easily put in there my 40-acre farm, you know, or put a street address or something like that. And he didn't bother to do it. And so in that situation, we'll stick him with the consequences of his poor drafting, basically. And so we could give Justin the big farm. This may be a silly example, because in reality, a judge might instead rule there was never actually a meeting of the minds, because we have to have mutual assent before we have a contract. And if we have something this huge that the parties aren't seeing eye to eye on, then the judge could also rule there was no meeting of the minds, there's no mutual assent in the first place, and so there was no contract. But of course, that would have ruined my example completely. But in reality, that might have actually happened. But so a situation like this, you know, where there's something that this huge, a judge might just say, well, you know, the parties really weren't on the same page from the get-go, and so there was no contract. But you know, sometimes this will come up though, where, you know, there's a situation where we're not quite sure what a term means, and well, the party who drafted the contract, you know, whatever ends up working out worse for them, that's what the judge might decide, and just stick them with the contract, you know, maybe on a term they didn't really intend. But, you know, this kind of just goes to show that you need to be careful when you're drafting a contract. You need to make sure that you say what you mean and mean what you say, because if you leave some kind of ambiguity, it's going to be construed against you if you're the one that is writing the contract in the first place. Now we're going to talk about something called the parole evidence rule. And a lot of times we'll have a situation where we end up with a written contract, but before we get there, the parties will have extensive negotiations first. They'll discuss the terms, they'll haggle over the price, when it's going to be delivered, how it's going to get there, how much money, all kinds of stuff. And so they'll be haggling back and forth. Finally, they'll reach some kind of agreement and sign a contract. But later on, they may end up disagreeing about what the contract actually means, what their obligations are, and they'll end up in court. And so when they get to court, they're going to want to argue about things they said during the negotiations and say, well, he told me this, and well, we said this term would mean this when we put it in the contract, and things like that. And so they'll want to use this evidence of what was said during the negotiations to prove what the contract actually means. And well, because of the parole evidence rule, that's usually not allowed. And so we're going to look at how this works. Well, discussions and negotiations, I can't spell, it says negations, but I meant negotiations, leading up to the contract is what we call parole evidence. And the word parole is probably parole, because it's French, some old medieval French or something, and it means something like word spoken or something like that. If you ever heard parlez-vous français, do you speak French? It's the same root word from Latin there. So anyway, it just means basically what was spoken, the words that were spoken. And so that's what we're talking about with parole evidence. It's like the spoken words that was said during these negotiations is what we're talking about. Well, the parole evidence rule states that parole evidence is usually not allowed in court to determine what the terms of a contract means. Instead, we're going to only look at the written contract language itself and assume that the words on the page are the sum total of the agreement. And so rather than, hear the parties bicker about he said, she said when they were negotiating the contract, instead of that, we're just going to plug our ears, hum a song to ourselves and read the contract and see what it actually says. And that's what we're going to stick with. And that's what the parole evidence rule says. We're going to ignore all that static from the parties about what they were talking about when they drafted the contract. We just don't care. As the older cases kind of put it, we'll just look and only look at what's on between the four corners of the document. So only what's on the written page. That's what when we're trying to figure out what the contract means, that's all we care about. That's what's on the four corners of the document. We're not going to take into account all this outside stuff and what the parties were talking about when they figured this out. So that's the general rule. But like every other rule, the parole evidence rule has exceptions to it. For instance, the biggest exception, we can look at parole evidence when we have an ambiguity. And so if there's some kind of contract term that we can't figure out, we will perhaps look at parole evidence and try to figure out what the parties actually meant when they were negotiating this contract by, taking their testimony, basically. What were you guys thinking? For an example, remember the farm a couple slides ago, where there's an ambiguity about which farm we meant. There were two farms in Jasper County. We didn't know if it was the 40-acre one or the 160-acre one. Well, in that case, Kevin was the seller there. And if we have an ambiguity and we don't know what farm actually means in this contract that's in writing, then Kevin could put on parole evidence, which would include, land prices and that no one in his right mind is going to sell a 160-acre farm for just $100,000. He could talk about the conversations he had with Justin, tell the court about showing Justin the 40-acre farm. He might have taken him out there and had him look it over, and that all our discussions were dealing with this particular parcel of land. And so all that stuff is parole evidence. It's outside the four corners of the document. But when there's an ambiguity, we can look at stuff like that to try to figure out what the contract language actually means. But we only look at it if we can't figure it out from the four corners of the document. So also, a court can allow this kind of evidence to show that the contract is void or voidable, such as, for instance, the parties claiming fraud or duress or undue influence. Then we'll look at parole evidence to see what the circumstances were leading up to the contract. For example, if you only sign the contract after someone pointed a gun at your head and threatened to pull the trigger, that's important parole evidence. We're going to want to know about that. If someone tries to enforce this contract against you and your defense is, hey, I was under duress, someone was going to shoot me, well, that's not on the four corners of the document, is it? But the court's going to want to know about that. And so parole evidence might come in that kind of situation too. So parole evidence can also be used to fill in the gaps if there's an essential term that was left out of the contract. If the parties, forgot to talk about, price or when it was going to be delivered or something like that, but all the other essential terms are there, and we might go look at parole evidence to kind of fill in those blanks. The court will, sometimes just imply a reasonable term but they can look at the intentions of the parties, and then we can get into the parole evidence stuff. We might also use parole evidence to reform or correct, just another term for correct, an obvious mistake. And by obvious, I mean, pretty obvious. For example, if a contract mistakenly said that you're going to deliver the goods on May 1st, 1910, and the contract was signed in 2009, well, we can't, get in our TARDIS and go back in time and deliver them in 1910. So we're going to instead just assume that the parties meant 2010. So, and that's what we're going to be able to apply based on parole evidence. The parties could testify, oh, we were talking, we really meant, next May instead of, 100 years earlier. So we understand those kinds of mistakes happen. We can use parole evidence to clear something like that up. Now we're going to switch gears a little bit and talk about third-party rights. Well, with contracts, normally that's between two parties. Those persons are said to be in privity of contract. In other words, they have come to an agreement. They have a relationship with each other based upon entering into a contract together. That's the privity of contract. So they have this legal relationship based upon being parties to the same contractual arrangement here. However, third parties may be affected by contracts entered into by others, even though they were not actually a party to the contract. They're not in privity of contract with the actual parties to the contract. They might still be affected by the contract in some way or another. So we're going to look at situations where this happens. One such situation is where we have an assignment of rights. Sometimes a party to a contract may want to give up his contractual rights to someone else who is a third party. And this is called an assignment of rights when this happens. Well, how might this happen? Let's look at an example. Here, Sam signs a contract with the Bank of Goodman. The bank agrees to loan Sam money to buy a house in return for Sam's promise to make payments on the loan with interest. This is a 30-year mortgage, and the Bank of Goodman doesn't want to wait for 30 years to get its money back. So it sells its right to receive Sam's payments to the Bank of Pineville. Well, the Bank of Goodman has assigned its rights to receive Sam's payments in exchange for money. Sam is now obligated to send his house payments to the Bank of Pineville. And if you've ever taken out a mortgage, this is exactly how it works. Your mortgage will get, change hands a dozen different times probably during its life. One bank will sell it to the other, and you'll have to send your payments to this new mortgage company every time they do that. And they are assigning their rights to your payments to somebody else in exchange for money. And so here we have third parties coming into the picture who have no privity of contract with Sam. So in this example, we really have two contracts going on. The first contract is between Sam and the Bank of Goodman, so they have privity of contract with each other there. In that situation, Sam is called the obligor, however you want to say it, because he undertook an obligation to pay back the loan when he signed the contract. So he's obligated to do something. He's the obligor. The Bank of Goodman is the obligee because it receives Sam's obligation and will benefit from it. Okay, so those are the parties to the original contract. So in this first contract, the Bank of Goodman exchanged its promise to loan money to Sam in exchange for his promise to repay the loan with interest. That's our consideration, a promise for a promise. And these are the parties we have in the first contract. Well, now we have a second contract. And this is just between the two banks. The Bank of Goodman entered into a contract with the Bank of Pineville. The Bank of Goodman exchanged its rights to receive Sam's payments in exchange for the Bank of Pineville's promise to pay some amount of money, whatever it was, in order to get this right assigned to it. So in this situation, the Bank of Goodman is the assignor because it assigned its rights to a third party. And that third party is the Bank of Pineville, the assignee, because it received an assignment of rights. And so that's our terminology in a situation of this kind. Well, here we have the Bank of Pineville and Sam, and they are not in privity of contract. They've never entered into a contract with each other, have they? They're never signed their names on the same document, to obligate themselves to do anything for each other's benefit. But ordinarily, we know a party who is not privy to a contract has no rights to enforce that contract. But here, because there was an assignment, the Bank of Pineville stepped into the shoes of the Bank of Goodman when the assignment of rights occurred. And so as soon as the first bank signed its rights over to the second bank, that second bank stepped into the shoes of the first bank has all the rights and obligations that first bank had. So it's now just kind of replaced, Bank 2 replaced Bank 1 here on this contract. So because of that, if Sam stops making his payments, the Bank of Pineville, who he never entered into a contract with, mind you, can sue him to enforce the contract he made with the Bank of Goodman, because the Bank of Pineville stepped into the Bank of Goodman's shoes. And this is true, even though the Bank of Pineville, was not in the room, when this original contract was signed. It's just a third party. It had the rights assigned to it, and so it steps into the shoes there. So the Bank of Pineville, the second bank, it can use any kind of tools the Bank of Goodman would have been able to use to make Sam pay his money there, because he is obligated to do that. Well, the flip side of that is Sam can use any defenses against the Bank of Pineville that he had against the Bank of Goodman. Again, the second bank just stepped into the shoes of the first bank. And so Sam has the ability to use any defenses against that bank that he could have before. So, for example, let's say the Bank of Pineville sues Sam because he stopped making payments, and Sam raises the defense of duress, saying that the president of the Bank of Goodman was pointing a gun at him and made him sign the original contract. Well, that defense, if it's proven, is just as good against the Bank of Pineville as it would have been against the Bank of Goodman. And the second bank stepped into the shoes of the first, and its rights under the contract are no better or no worse than the first bank's would have been. So again, we basically just one bank is replacing the other bank here with all its rights and obligations. And so if Sam has a defense against the contract, he can assert that defense against the second bank just like he could the first, because one just replaced the other. Well, normally we can assign rights if we want to. That's kind of the general rule. We can assign whatever rights that we want to, unless the contract specifies otherwise. But there are certain situations where the law says there are rights that you cannot assign away. An important instance of that is what we call personal services contracts. So if it's important that a particular person perform the services, then an assignment may be prohibited. And usually it may not be important. If you have a contract for somebody to haul away your garbage, you may not care, who actually hauls away the garbage, as long as the garbage gets hauled away. But sometimes who is performing the contract is very important. For example, let's say that some Branson theater enters into a contract with Tony Bennett, who, if you don't know, is a singer, to sing on Friday nights. Well, Tony doesn't feel like performing that night and wants to make a quick buck, so he assigns his rights under the contract to Joe Schmuck, whom he just meets in a bar. Well, the theater, of course, doesn't want Joe Schmuck to sing. It wanted Tony Bennett. And so this is a personal services contract, and the rights can't be assigned without agreement from the theater. Tony can't just hand it off, to somebody else and let them perform the contract for him. And so in a situation like that where it's important who is performing the contract, and then we're not going to let an assignment happen, potentially in a case of that kind. Another situation where the law won't allow an assignment of rights might be a situation where an assignment would materially alter the risk to the parties. What does that mean? Well, I think we can learn what that means by looking at this example here. Let's say we have State Farm, which is an insurance company, enters into a car insurance contract with Lois, who is 40 years old, very mature, and a perfect driver. Never had an accident in her life, no speeding tickets, none of that stuff. So State Farm evaluated its risk before entering into that insurance contract and adjusted Lois's premium accordingly. It would be unfair to State Farm to allow Lois to assign her contract rights to her 21-year-old son James, who has already had 2 DWIs and a conviction for reckless driving. And doing that would materially alter State Farm's risks, and an assignment is not allowed without its prior agreement. So you can see here, State Farm can sleep well at night knowing it's insuring Lois, but it would be very nervous insuring her son, who's a malcontent here. So in a situation like that, we wouldn't allow an assignment to occur because one of the parties would incur a much different level of risk if we allowed an assignment. And so in a situation like that, we're not going to allow the assignment to occur without the permission of the other party. Also, many states will prohibit the assignment of rights to pursue certain legal actions. For example, if you're injured in a car accident, many states will not allow you to assign your right to sue the negligent driver who hit you to somebody else. You can either sue them yourself or no one's going to, but you can't sell your rights to sue them to a third party. We won't allow that. And a lot of tort cases, we just won't allow you to assign your rights to sue somebody. It's just kind of unseemly, I guess, to be selling your right to sue whoever caused the accident in a situation like that. So a lot of states don't allow that. However, that's torts. If we're just talking about true contracts, rights to sue for breach of contract are bought and sold all the time. And that's not that uncommon at all. For example, let's say you go to Freeman Hospital for a broken leg. You sign a contract that you'll pay, of course, your medical bills in exchange for the treatment. Well, 6 months later, your leg is healed up, but you still haven't fulfilled your obligations. You haven't paid off your medical bills. Freeman may call you a few times trying to collect that, but probably they're not going to waste their time too much. They're going to turn it over to a collection agency, which means that they will sell their right to collect that debt, probably at a very deep discount, to a collections agency who will try to make your life hell. And by harassing you mercilessly, they might take you to court and sue you to get it. They will be calling your house, and they will, send you letters and, all kinds of fun stuff, because they will step into Freeman's shoes. Once they have that right is assigned to them, they will buy the right to go after you to collect that debt. And so that kind of thing happens all the time, and that's just an example of an assignment of rights. Well, we looked at assignment of rights. We also have kind of the flip side of the coin, delegation of duties. A contract right is usually the good things that are coming from belonging to a contract. Here, the right to get paid, the right to receive goods or services. It's the good stuff that's flowing from that contractual arrangement. It's when we're dealing with an assignment. That's usually what we're dealing with, is some kind of contract right. But we also have duties. And those are things that have to be performed by you, obligations, obligations to pay money, and obligations to ship a load of widgets or perform some kind of service, something like that. The actual work that has to be done in order to earn the money, basically. And so those are duties. While rights can be assigned, duties or obligations can usually be delegated to a third party. The terminology is a little bit different, but the concept is exactly the same. Usually we can hand off these duties or delegate them to a third party. That's the general rule, that we can do that. For example, let's say that we have Big Mart, a big retailer here, wants to build a new store, so they enter into a contract with Ron's General Contracting to build the store. The contract specifies exactly how the store is to be built and says it must be provided with electrical wiring. Well, Ron's is a general contractor, and he doesn't do electrical work. So Ron's enters into a second contract with Bob's Electric to wire the new building. So Ron's has delegated one of its duties under the first contract with Big Mart to Bob's Electric. And so, Ron signed a contract saying the building had to be wired, but he doesn't do it himself. He just delegates that to a subcontractor here, and that kind of thing happens all the time, and that's perfectly okay to do that. So in that example that we just saw, again, we have two contracts. In the first, we have Ron's Contracting, the general contractor. He's an obligor because it promised to perform a duty. Big Mart is the obligee because it is the beneficiary of that promise. Okay. Well, in the second contract, Ron's delegates part of its duties to a third party, Bob's Electric. So in that situation, Ron's is the delegator, and Bob's Electric is called the delegatee. That or and e pairing is used a whole lot in legal jargon, if you haven't figured that out yet. So that's our terminology there. Well, now, under the second contract, Bob's Electric is obligated to perform services for the benefit of Big Mart. And if Bob's Electric doesn't perform, it can possibly be sued by Big Mart for that. It can definitely be sued by Ron's. So anyway, Big Mart has some potential options there if its store doesn't get wired like it's supposed to there. Well, if Bob's Electric doesn't perform, Big Mart may be able to sue Bob's Electric. Whether it can or not is based upon whether the delegation to Bob's Electric constitutes an assumption of the duties of Ron's, or whether it's a declaration of duties. Well, what does that mean? Well, we're not really going to worry about it too much because it gets very, very complicated. We don't want to get in the weeds too much on this, but just know that Big Mart may or may not be able to sue. So we'll stop there and not really worry about whether it actually can or not. just know that it may or may not, depending on what this is actually classified as. You have to have one or the other. We're really not going to spend too much time worrying about which it actually is. But no matter what, Big Mark can still sue Ron's, the general contractor, if Bob's Electric doesn't perform, because it was, even though Ron delegated his duties away, it's still going to be liable under the original contract. And so Big Mark can still sue Ron's if that wiring doesn't get done. And then Ron, of course, can turn around and sue Bob. That's no problem. But Big Mark might be able to sue Bob's Electric directly, maybe, maybe not. We are not sure, but he can definitely sue Ron's in a situation like that. So even though Ron delegated his duties away, he's still liable under the original contract to Big Mart, unless and until the original contract is terminated. And if that happens, Ron will be off the hook. But until then, he's still going to be liable to Big Mart, even if he delegates some of his duties away. And so Ron, of course, can always sue Bob's Electric because they are in privity of contract because of the second contract. So if Bob screws up, he's going to get sued by Ron. He might get sued by Big Mart, and Big Mart can always sue Ron. And Ron can always sue Bob, but Big Mart might not be able to sue Bob directly. So, like I said, it's a kind of a complicated situation. But anyway, that's kind of, in general terms, how that all stacks up there. Well, when we're talking about delegation of duties, the same sort of restrictions apply that we talked about with assignment of rights. So the default rule is you can delegate duties, but again, delegation is not allowed with personal services contracts or if the performance would materially vary in some way. Remember the insurance contract that we saw, if the risk of the parties is going to be greatly changed or the level of performance is going to change in a drastic way, that's not going to be allowed. So, for example, if you reserve a room at the Four Seasons, they cannot delegate their duty to provide that room to you to the Motel 6 down the street, and the level of performance there would vary a lot, and so we're not going to allow them to do that because it would just be too much. The parties to the original contract can also include a provision that prohibits the delegation of duties, and so if you don't want your the rights to be assigned or the duties to be delegated, you can put that in the contract. That's fine. This is just a default rule, is it can be done, but for these exceptions. But you can always bargain this, put this into the contract. If you don't want this to be done, just put it in the contract. You don't want this to be delegated away, and you can do that, and then it can't be done. Let's shift gears again and talk about third-party beneficiaries. Sometimes contracts entered into by two people end up benefiting a third person. Sometimes that's by accident, sometimes it's by design. And so we're going to look at situations where we do have a third person who is benefited by the contract, what their rights are, and how they're affected. If this happens on purpose, we have what's called an intended third-party beneficiary. The third party may even be named in the contract itself. For example, let's say that Travis wants to provide for his wife, Kim, if he should die. So he takes out a life insurance policy with Great Benefit Life Insurance Company, naming his wife as his beneficiary. And of course, that means that she's the person who would receive the proceeds of the life insurance policy if he dies. So life insurance is just a contract, just like any other contract pretty much. So later, Travis is brutally attacked by a roving flock of rabid pigeons and dies. A terrible tragedy. So Great Benefit must pay the proceeds of the policy to Kim, and if they don't, Kim can sue them. Because she's a third-party beneficiary, she is named in there, so she's an intended third-party beneficiary. She has the right to sue to enforce the contract if the insurance company doesn't come through after her husband is tragically killed here. In this situation, the terminology, we say that Great Benefit is the promisor because they made a promise to perform the contract, that is, pay the money if Travis dies. Travis is called the promisee in this situation because he is the recipient of the promise. And so he entered into this relationship. The insurance company promised Travis they would pay his wife. So she's getting the money, but he's getting the promise. Kim is the third-party beneficiary. And more specifically, she's known as a donee beneficiary because the benefit was donated to her by this contractual arrangement. In other words, she didn't have to do anything to earn this. She didn't have to perform anything. She just has to sit there and collect the check. And so she doesn't have to perform any obligations. She's just going to get the benefit. So she's the donee because this was donated to her. She didn't have to work for it. Well, sometimes we have an intended third-party beneficiary in a commercial type transaction. And so then we're not dealing with a donee beneficiary. We have what's called a creditor beneficiary. For example, let's say Julie wants to sell her house. She agrees to sell the house to Marcia, financing the house herself. Marcia will live in the house but make monthly payments to Julie with interest for 10 years. Well, Marcia and Julie sign a contract to this effect. After 2 years, though, Marcia decides to move out of state. So Marcia enters into a second contract with Aaron, who agrees to take over the payments on the house. So Aaron will make the payments to Julie. So in this situation, Marcia delegated to Aaron her duty to send Julie the monthly payments. So that makes Julie a creditor beneficiary to this second contract. And so again, we have the first contract, then we have the second one. And then the second one, Julie is the third-party beneficiary because the contract's between Marcia and Aaron, but Julie's going to benefit from it. But she, actually had to do something here. She has provided the house that's being sold. So she's not a donee beneficiary. She's a creditor beneficiary in this situation here. And Julie's not a party to the second contract at all. She didn't sign on the dotted line there. That was just between Marcia and Aaron. But if Aaron stops making payments, Julie can go sue him. She does have rights, even though she's not a party to that contract. She's a third-party beneficiary. Also, in this situation, Julie can still sue Marcia, even though she delegated her duty to pay to Aaron. And so if you're Marcia, that's a red flag, I guess, there. If you ever find yourself in this situation, you might not want to go forward with this because it's kind of a bad deal for Marcia, because if Aaron ends up being a deadbeat, Julie can still come back and sue her, even though she tried to delegate everything, or all of her duties to Aaron. If he falls through, Julie can sue Aaron, but she can also still sue Marcia. So in this situation, the original debtor is still liable on the contract, unless the creditor beneficiary, which in this case is Julie, agrees to terminate that original contract with the original debtor, who's Marcia, and let her off the hook. And if they do that, that's called a novation, and we'll look at that a little bit more later. So if you find yourself in a situation like this where you're trying to sell your house in some kind of creative way, I've actually heard of situations where this happened, where somebody just tried to turn over the mortgage payments to somebody else, and move out of state, and that person that they sold their house to stops paying the mortgage. Well, the mortgage company can come after the person who's living in the house, but they can also come after you after you thought you'd gotten rid of the house. They can look you up and wherever you move to and say, we're owed some money here because you're still under contract, unless they agree to terminate that original contract. And so it's very important in a situation like this that you make sure that that original contract is no longer going to be burdening you if you want to do this, because you want to get out from under this house. So anyway, kind of a bad situation potentially. So be careful if you ever find yourself in a situation like this. Well, we've seen how the intended beneficiary has rights to sue to enforce the contract. And that's an intended beneficiary. We also have incidental beneficiaries, and they don't have the same kind of rights to enforce a contract like an intended beneficiary. Let's look at an example of an incidental beneficiary here. George owns 160 acres of land. George entered into a contract with Big Fun, Inc., whereby George would lease his land to Big Fun, and Big Fun is going to build an amusement park on George's land. Well, Sally hears about this deal, and she rushes out and buys some land across from the road from the future amusement park so she can build a convenience store there and make lots and lots of money off the people who are coming to the amusement park. So she builds her store. But Big Fun breaches its contract with George, ends up never building the amusement park. So Sally tries to sue Big Fun, claiming it's breaching the contract with George meant lost profits for her convenience store. Well, clearly, Sally was never intended as a beneficiary of the contract between George and Big Fun. They weren't thinking about Sally when they entered into this contract. She's not an intended beneficiary. So in this situation where Big Fun breaches its contract, George can sue him, but Sally has no standing at all to sue them based on this contract, because it really didn't concern her at all. She might have benefited from their arrangement in kind of a, not a very direct way, an indirect way. But she wasn't intended to be a beneficiary, so she's just not going to have any standing at all to sue. So sometimes we'll see in cases there's a debate whether a third-party beneficiary is intended or incidental, because sometimes it's actually kind of debatable. But if it turns out that they're incidental, they just have no standing to sue anybody at all. So it is an important distinction to make. We're going to shift gears a little bit again and talk about another topic, covenants and conditions. Parties to a contract, they make various promises to each other on what their actions will be in fulfilling the contract. There's two basic kinds. A covenant is an unconditional promise to perform. There's no strings attached. When they enter into the contract, they're bound to perform a covenant, no matter what, basically. So they must follow through with it, no strings attached. For example, Jerry takes out a loan from the bank at Granby to buy a used car. He signs a note, which again is a special type of contract, agreeing to make payments to the bank every month with interest. Jerry gets the car and discovers it's a lemon, it won't run. Jerry's very unhappy. He refuses to repay the bank loan because his car stinks. The bank can sue Jerry and force him to pay because his promise to repay the loan was unconditional. It was a covenant, and he must perform no matter what. So he picked out a lemon, but that's his problem. He still has to repay the bank. That was a covenant. It was unconditional. There were no strings attached. He had to fulfill his promise there. So that's a covenant. Well, covenants are unconditional. Other promises do have conditions attached. A promise with a condition basically says, I promise to perform if X happens. And so if X happens, then the promise becomes binding. It has to be performed. But if X does not happen, then the promise does not have to be performed. In that situation, X, fill in the blank, is what we call a condition. So let's look at an example here. Ben buys a life insurance policy, which, as we've seen, is a type of contract, from Stark City Mutual Insurance Company. The insurance company promises to pay Ben's wife $1 million, but only if he dies. Ben's death is a condition precedent to the insurance company's performance of its duty to pay. Ben's promise to pay the insurance premium is unconditional, however. But the insurance company, if Ben is still alive and he's breathing, they don't have to pay the $1 million. Only if he dies do they have to pay. So that's a condition that's attached to that contract there. This type of condition is called a condition precedent because something has to precede or happen before the other party is obligated to perform. So Ben has to die before the insurance company is obligated to pay. Its performance obligation is tied to whether or not the condition is met first. And so Ben has to perform. That's a covenant. He has to pay a premium. But this paying the benefit to the wife here, that is tied to a condition precedent. So only if Ben dies is the insurance company have to pay out the money. Well, some contracts condition performance on one party's satisfaction. So that's a type of condition. And satisfaction gets to be kind of a tricky deal. For instance, this example, I will pay you to paint my portrait, but only if I am satisfied with the result. So if you're sitting to have a portrait made, which I've never done, maybe you have, I don't know, but you can expect, if you think it's ugly and you don't want to hang it on your wall, you don't want to pay for it either. And so you'll only pay for it if you like the way it turns out. So you can understand why somebody might do that. So that would be an example of a condition. But here, what's problematic is how do we measure satisfaction? How do we determine what that actually means? And you can do it in two different ways. One is a subjective test. We will look at what the person is actually thinking. Does the person who made the contract like this painting? And this is usually only applied to situations where, like this one, where someone's having their portrait made. That the person sitting for the portrait may have what any sane person would think is bad taste, but it's their portrait, and they should end up liking the end result. And so we will look at what the person who entered into the contract will look at what they actually are thinking. That's a subjective test, and that's not usually normally what happens, but sometimes that'll be used in a situation like this one. More often, though, parties are going to look at the objective test, and they will look at what a reasonable person would think. Would a reasonable person be satisfied in this situation? And so that ends up being a much fairer standard. It applies to commercial contracts, and it's fairer because if we always apply the subjective test, well, a dishonest person is going to come along and say, well, I'm not satisfied, and they're just going to refuse to pay. And so if we use the subjective test, how do we know? How do we get inside their head and know if they're lying, that they actually are satisfied and they're just not telling us? So that would be a real problem. And so usually we'll use the objective test or the reasonable person standard and try to figure out, would a reasonable person be satisfied in this situation? So that's normally
what we will be looking at. Let's look at an example of the objective test in action here. Russ hires a contractor to build a house to his satisfaction. The contractor completes the building, and by all reasonable measures, the building is just fine. It's the best house anyone has ever seen. It's structurally sound. The contractor followed the architect's drawings to the letter. Every professional inspector who looks at the house thinks it's the best built structure they've ever seen. However, Russ refuses to pay the contractor because he is not satisfied. So the contractor sues Russ, demanding that he perform under the contract and pay what he owes. The court applies the objective test and finds that any reasonable person would be satisfied by the house. It meets all construction industry standards, and so Russ is going to be ordered to pay. And so even though it said his satisfaction, the court will read in there, well, what a reasonable person would be satisfied with and make him pay, because it would be unfair not to. And so that's what the court would do usually in any kind of commercial contract sort of situation there. Talking about conditions and covenants, well, sometimes a contract will contain a time in which performance must be made that will look like some kind of condition that's attached. For example, you might hire a contractor to build your house and complete the job on or before August the 1st. So that looks like a condition that they're going to have to meet. If the time frame of the contract is not met, one of the parties may claim that performing within that time frame was a condition precedent and refuse to pay if the job wasn't done on time. Well, are they going to get away with that? Well, it depends. If the contractor, in our example, finishes your house on August 2nd, you could claim that he breached the contract, and you would be correct in that. He technically breached the contract. The question is it a material breach? Is it really serious enough to excuse you from performing and you not have to pay him to do that? Well, courts will not normally say that a time frame like this is a condition precedent that'll let you get out of performing. So as long as the delay is minor, you probably the contractor is going to be okay. Now, if he's 6 months late, that's a whole different story. If he's 24 hours late, that may not be a big deal. But if he's going to, it depends on the circumstances. He could be really, really late, and that may end up being a material breach. Usually, though, a short delay is considered a minor breach that will not excuse performance by the other party. But sometimes contracts will contain a time frame in which performance must be made. And the exception to the rule there that we just looked at, where it's just a minor breach, is if the contract specifically says time is of the essence. And those are magic words. If it says time is of the essence, that means that the time frame is considered a condition of performance, and any delay is a major breach of the contract. And so if you're really, really serious, you want your house done on August 1st, and August the 2nd is too late, darn it, you need to put that in there. Time is of the essence, and then that'll let you out if they don't get it done on time. And so that's very important, because otherwise the time frame is probably going to be viewed as a minor breach. And so if you really want to make sure it's a material breach, if it goes a second too long, time is of the essence needs to be in there. Well, the example of conditions that we've looked at before were conditions precedent. Something had to be done before performance was required. There can also be conditions subsequent, where performance is required unless and until an event occurs, and then performance is excused after that event occurs. So what does that mean? Well, let's look at an example. Let's say a school district hires a teacher, and the employment contract states that the teacher must be able to pass random drug screenings. So the teacher is employed for 6 months and then fails a drug test. Well, after that condition happens, the school is excused from performing. In other words, they don't have to continue employing the teacher. They can fire him and stop paying him. So he may be smoking doobies this whole 6 months, but they still have to keep paying him. Then when he fails the drug test, then they're excused. And so that condition is a condition subsequent to that condition being satisfied, they no longer have to perform. So it's the same thing as condition preceding, it's just kind of backwards on the timing issue. But it's a different classification of a condition, but when that's met, they're excused from performing. Well, let's look at discharge. How are parties going to be discharged from a contract and be free of its obligations? In other words, all contracts eventually die and go out to pasture. So when you sign a contract, at some point you're going to be free of those obligations. When does that happen? Well, it happens when the parties are discharged. And discharge can happen in a number of different ways, but it describes the instant where the party is no longer obligated to perform. They have done all they need to do under the contract and they're free of it. Well, if all goes well, a party is discharged once he has fully performed all of his obligations and duties called for in the contract. So hopefully in a perfect world, both parties will do everything they're supposed to do under the contract. When that's done, ta-da, it's fulfilled and they're off the hook. They're no longer obligated under the contract. They have fully performed. And so that's how discharge happens in a perfect world where everyone follows through on their contracts. Well, discharge can happen in other ways too. Sometimes both parties to a contract may decide that they just don't like the contract, it's not working out, and they will agree to just tear up the contract and move on with their lives. If they decide to do that, that's called a mutual rescission. So they both agree, so it's mutual, and they rescind it, and they just tear up the contract and just pretend it never happened. So in a situation of that kind, both parties just agree to stop performing and walk away. It's no longer a good deal for either one of them, so they will just rip up the contract and move on with their lives and forget about it. And so that can be a way that they can be discharged if this happens through mutual rescission. You can also have a discharge if both parties agree to replace the current contract with a new contract. So they decide the old contract's not a good deal, they'll decide on a new one. Then when they enter into this new contract, it will revoke and cancel the old one. And thus it will discharge their responsibilities under the old contract. This is what we call a novation. Nova is the Latin word for new. So we have a new contract that replaces the old one. And so as soon as this new contract comes into force, the old contract is dead and gone, and the parties are discharged from whatever responsibilities they had under the old contract. Let's look at an example here. This is another house selling example, very similar to what we've seen before. Julie wants to sell her house. She agrees to sell the house to Marcia, financing the house herself. Marcia will live in the house but make monthly payments to Julie with interest for 10 years. Marcia and Julie sign a contract to this effect. After 2 years, Marcia decides to move out of state. So she finds Aaron, who wants to take over the payments on the house. Marcia approaches Julie and says, "Hey, I want to move, and Aaron wants to take over making the payments on your house. Is that okay?" Julie says, "Sure." So Julie and Aaron agree to a new contract where Aaron will take over the payments. Julie then releases Marcia of her obligations under the old contract, and Marcia is no longer liable to Julie if Aaron should stop making payments. And so we saw how, in this example, when we saw it a little bit earlier, Marcia was still on the hook in the old example because there wasn't a new contract. She was still obligated. So when Aaron was a deadbeat and stopped making payments, Julie could, of course, sue Aaron, but she could also come after Marcia, even though Marcia was long gone and moved out of state. Well, in this situation, Marcia's smart. And she says, well, let's rip up that old contract and you can enter into this new one with Aaron. And so in that case, Marcia's off the hook. And so Julie can't come after Marcia anymore. She can only come after Aaron. So that's, we have a novation here. The old contract is replaced by the new contract. And in the process, one of the parties was replaced by someone else. So the original party's obligations under the contract are discharged. Marcia is no longer on the hook. And so this is what a smart Marcia does. So if you ever find yourself in this situation, make sure there's a novation, because you don't want to move out of state and 5 years later Aaron stops paying his payments, and so you get sued for a house you thought you sold 5 years earlier. So very important you get a discharge from the original contract obligations. Well, another way you can get discharged is through accord and satisfaction. We looked at that already. It's basically a special type of novation. If the parties reach a settlement and agree to terminate the contract, that constitutes a discharge of their obligations to one another. And so they just say, well, we're going to change the terms of the first contract. We'll rip that up, do something new, and we'll just settle the deal and walk away. So that's a way you can get discharged if you have that accord and satisfaction.
Sometimes a discharge can happen not because of anything that the parties themselves have done, but because there was some kind of external event that was beyond their control that happened and that will end up excusing their performance. One such situation happens with the doctrine of impossibility. Sometimes it is literally impossible for the contract to be fully performed because of some external event happening. And when that happens, we'll let you off the hook and discharge you from the contract rather than forcing you to go ahead and perform it, because we know that's impossible. Let's look at some examples of when this might occur. For instance, you might have a situation where one of the parties to the contract passes away before the contract is fully performed. Let's say that you hire Tony Bennett to come sing at your wedding, and before your wedding day, he passes away. And so it's going to be impossible for him to come sing at your wedding if he is dead. And so if that happens, we're not going to, charge someone with breach of contract or something like that. We're just going to recognize that it's impossible to fully perform, and so we'll discharge the parties from any further obligations under the contract. Let's say that you have a band, and the band is hired to play at a particular concert venue on a particular night, and they sell tickets and all of that there, but then the building burns down, and so it's impossible to use it for a concert because it's a pile of heaping ashes there. In a situation like that, it would be impossible to go ahead and perform, so we will let you off the hook. Let's say that you have a drug company, and the drug company signs a contract to sell this particular brand of drugs. Well, then the FDA declares that those drugs are dangerous. It pulls them off the market. It's now illegal to sell the drugs. Well, it's still, theoretically possible, I guess. The drugs are still there. You could, theoretically sell them, I guess, but then you'd all go to prison. So if a situation like this where it's legally impossible to go ahead and continue performing the contract, we'll let you off the hook. We'll discharge it. So basically any other kind of event, the possibilities depend upon the circumstances, but really anything that literally renders it impossible to perform on the contract, we'll discharge the parties from their obligations so they can walk away from the contract at that point if it is legally or factually impossible to perform. We'll discharge them from their obligations. Sometimes it's somewhat debatable whether something is literally impossible or not. For instance, we had the situation with the band that was going to perform the concert and their venue burned down. And so they might, the band, if they want to get out of the contract, they could say, well, look, where you were going to have us perform, that's all burned down. It was the only place in town that had that many seats and you sold the tickets. And so, let's just say it's impossible and walk away. But maybe the concert promoter said, no, I have this other venue that has half as many seats and you need to come perform there or something. There might be some kind of debate about it. And so you can draft a contract in such a way to deal with these kinds of situations. So you won't end up in court fighting about it later. You can just draft however you want to handle it into the contract. So a lot of contracts that you look at will have force majeure clauses, a nice French term, I suppose, that excuse performance and discharge the parties if something really bad happens. And it may be technically possible to perform, but the force majeure clause can be drafted in such a way that if it's pretty much impossible, it'll still let you off the hook. For example, let's go back to our band holding a concert thing. Let's say, though, that in this situation, the venue didn't burn down, but instead of that, we have a Category 5 hurricane headed for Florida, and then right where they're supposed to perform, is where the eye of the hurricane is hitting, and it's supposed to make landfall the day of the concert. Well, and let's just say it's an outdoor concert to make it even more interesting. Okay, well, is it technically possible to perform? Yeah, probably. You could be out there in a Category 5 hurricane trying to play rock and roll, I suppose, if you really wanted to, but is it really, does anyone want to do that? Would it make sense to do that? No. And so you could draft the contract in such a way that if, the hand of God, Mother Nature, however you want to look at it, intervenes, it'll let the parties off the hook. And so a force majeure clause properly drafted could handle a situation like this and let the band out of the contract if something like this is happening. Force majeure clauses, they can deal with all kinds of doomsday scenarios, and I've seen all kinds of ones that will deal with all kinds of crazy issues that might crop up. If you want to see some examples of that, you might look at your car insurance policy sometime. And I'm not talking about the little card that you stick in your glove box. When you first sign up with your insurance company, you ought to have some stack of papers that is actually your policy. And if you look in there, they'll have all kinds of interesting things that'll let them off the hook if something bad happens to your car, and they consider it a force majeure. So it might let you off, for example, acts of terrorism made its way in there after 9/11. And so if your car gets blown up in a terrorist attack, the insurance company might not have to pay for it because that's written in there. A popular one that came out of the Cold War, nuclear war, is actually mentioned in a lot of car insurance policies because I guess, the pointy little headed lawyers that were sitting in the basement of State Farm drafting these things, thought, oh my goodness, can you imagine what would happen if there was a nuclear attack and the Soviet Union launched their nuclear missiles and blew up 13 billion cars across the United States? We would be on the hook to pay all those claims, and so they wanted out of that. And so a lot of car insurance policies will actually excuse them from performing on the contract if there is nuclear war that blows up your car. So kind of interesting there. Honestly, I would have thought they would have realized that after the nuclear war, paying claims would have been the least of their problems. But anyway, it's in there. So this is a fairly common thing and a very wise thing to put into a contract potentially. Sometimes performance of a contract may not be technically impossible, but it may be pretty close, what is called impracticable. So it's technically possible, but it may make no sense, or one of the parties would just lose their shirt if they went ahead and had to perform under the contract. And so sometimes a court will let them out of that situation and excuse them from performance and discharge them. So again, circumstances have changed since they entered into the contract. So performance is technically possible, but one of the parties is really going to be injured financially by performing the contract. Let's look at an example here of how this might happen. Let's say that Acme Corporation signs a contract to produce platinum commemorative coins for a retailer at a cost of $100 per coin. Acme expects to make $15 on each coin it produces. After the contract is signed, a revolution occurs in the country that produces 90% of the world's platinum, and the price of platinum on the world market goes up 500% overnight. So Acme could still perform, and it would still be able to buy platinum and make coins, theoretically. But if it does, it would go from making money on each one, $15 on each one, to losing $200 on every coin it produces, bankrupting the company. So in such situations, courts often use the doctrine of impracticability to excuse performance of the contract. So in a situation like this, it's technically possible to perform, but again, Acme Corp is going to lose its shirt on this deal. It could maybe go into bankruptcy, and the company would have to liquidate and fire all its employees, and that would just, is that going to serve anyone's purpose if that happens? And the answer is no. So whomever signed this contract with Acme, they could, jump up and down and scream and say, oh, but, we signed a contract and you promised to give us these coins, and, you can still get platinum. It still is on the market. That's not our problem. The price went up. Well, all those things may be true. But in the big picture, does it really serve anyone's purpose to force Acme to perform in this situation? Lose money, go out of business. Lots of hardworking Americans are, looking for work now and all that. So a court in that situation, this is kind of a gray area. A court could go either way on some of these types of cases. But in a situation like this, it might just not make any sense at all to force a company to commit suicide like this. And so we might let them out of the contract and discharge them, not because it's impossible, but because it's impracticable. It could happen, but it just doesn't make any sense. Well, continue with discharge. One more thing that will discharge you from contractual obligations, potentially, is bankruptcy. If you declare bankruptcy, the judge has the power to tear up contracts you made with your creditors to pay them money. For example, let's say that you sign a contract with your credit card company promising them that you will pay them back for purchases made with the card. So when you get a credit card, in order to get that card, you have to sign a contract saying you're going to pay your credit card bill. Okay. Well, you declare bankruptcy. It says bankruptcy. I don't know what that is. It's supposed to be bankruptcy. I guess I can't spell. Anyway, when you declare bankruptcy, and we'll look at bankruptcy in a future chapter later on, and when that happens, the bankruptcy judge can discharge that debt, excusing your performance under the contract. The whole purpose of bankruptcy is to give people who are in over their head in debt a fresh start and wipe their slate clean and send them out into the world again with no debt, so they can kind of build their life back together. So in this situation, the creditors, might get stuck. Your credit card company might get stiffed, because what will happen is the bankruptcy judge says, oh, you know what, this guy is never going to be able to repay this debt, so I'm just going to cancel it. And he can do that. He can discharge the debt in bankruptcy. And so that will discharge you from paying your debts, your bills. So if that happens, certainly you're off the hook. You're discharged from that contract. It also ruins your credit for a good 10 years or so. So not a good situation to get into if you can possibly avoid it, but that will lead to a discharge. So I believe that is our material for this week. Hope you have a good week, and I will talk to you next time.